Hi, this is Henry Kim, and I am here to make another video. This one is going to be a very brief video, and in this video I'm exposing another Canadian judge by the name of Suzanne E. Fraser, and she's a judge in the Superior Court of Justice in Newmarket. And she's just one of a long line of corrupt judges in Canada who who carry out human rights abuse and to the extreme. So in this video, I'm going to focus on some stuff that she has done, which was willfully done to cause me irreparable harm. She also lied in her decision. Now, this may come as a surprise to you to hear someone say a judge lie, but please get real. The courts are corrupt. The judges are corrupt. Judges lie, lawyers lie, police lie. These are officers of the court and they lie. And it's a shame. It brings disrepute to the administration of justice, but that's just the reality. So this judge lied. Okay, how did she lie? Well, I filed an urgent motion on the rules 37.17 of the Rules of Civil Procedure, which basically allows me to file an urgent motion or any motion before the commencement of a proceeding. In her decision, which she denied my urgent motion, again, like the other previous judges before her, Laura Bird, and Sutherland, and all of them, she denied my urgent motion requiring service on the respondents. Now, I'm going to show you that this judge lied in her order, in her endorsement, because she stated in her decision that I gave no indication in my urgent motion that the motion was made under Rule 37.17. This is paragraph 2 of my urgent motion. Look what I highlighted. Do you see where I state, okay, that the urgent motion was made under Rule 37.17? Okay, read it. This is where it states under paragraph 2 of my urgent motion. I specifically stated that it was made under 37.17. Okay. The rest of the document shows my urgent motion. She also made some other stuff on there. This is an urgent motion, an ex parte motion, so it was done in writing. But I was reading her endorsement, and it's saying present. I hope you can see it. Present. So it's saying I was present and self-represented. And it's also saying that the defendants were present also. But at the same time, it's saying that the motion was heard in writing. Do you see where it says heard in writing? Okay. Which means that the parties were not present. Yet somehow she has present there. But that's not the concern. The concern is the rest of her order. In paragraph 4, subsection C, I hope you can read it. And I hope you can read all of it. Where she's stating that I gave no indication in the motion that there appears to be, verbatim, there appears to be no intended proceeding. So she's saying in paragraph 3 that there appears to be no intended proceeding in my urgent motion. I already showed you under Rule 37.17 in my urgent motion, which allows me to do the motion before the commencement of a proceeding. How did this judge come to the conclusion that there appears to be no proceeding when she's looking at Rule 37.17, which allowed me to do the motion before the commencement of a proceeding. Why the fuck are you? Why are you, excuse my language, why are you focusing on that rather than the urgency of the motion? And then if I go down further on in her, I didn't copy the whole goddamn endorsement, just the relevant part. So in paragraph 7, she's telling me to proceed with her case on the merits. I'm going to show you, okay, because I can't read it. It's backwards to me when I do that. So I'm going to read it and then I'm going to show you. To proceed with her case on the merits, Miss Guillaume must A. commence an action or application to show that she intends to do that. B is the troubling part. B, she must serve the persons or institutions who she claims have wronged her or against whom she is seeking an order. Pause. I don't have to serve the other parties before my urgent motion can be heard. The very fact that it's an urgent motion means that there's an urgency. And obviously, under the rules, I think it's Rule 16, service, they don't have to respond right away. There are certain periods. I think it's 30 days or whatever it is. But with an urgent motion, you can try to bring it back within 7 days. I've requested that and that has been denied. Okay. So you don't have to serve the respondents if it's an urgent motion, because this urgent situation requires the court to address it immediately. That's the whole purpose of an urgent motion. And if you read the earlier part of my motion, I asked the court to dispense. If you read the rest of my paragraph 2, I specifically asked the court to dispense with the formalities of a regular motion so that the urgency could be addressed in this urgency. What was the urgency? That the place that I was using after the court refused to allow me back into the shelter was closing on June 15th. So I made this urgent motion on June 12th, I believe I signed it. So the judge heard it on June 16th. On June 16th, the judge knew that I would be facing irreparable harm because the place closed on June 15th. And she had the urgent motion, actually. The court had the urgent motion since June 12th, but she didn't hear it until June 16th. She knew on June 16th that I would be facing irreparable harm with now being completely homeless. And she still made the urgent in her decision that service be made on the respondents, which is the regional municipality, by the way, because they own the shelter, and the Salvation Army that operates it on its behalf. So this whole thing was a humiliation ritual by all of them, the judges in the court. Also reprisal, because I was exposing some other ones in the courts that did the same thing. None of them regarded the urgency of my situation. All of them required service on the respondents, which obviously is going to delay the situation. And obviously by the delay is going to cause irreparable harm. This judge, Susan Fraser, is a corrupt piece of shit. She lied because either she was willfully blind, that she could not see that I stated in my urgent motion that the motion was made under Rule 37.17, right here, where you see the asterisk. I stated the grounds under which the urgent motion was made. And she was willfully blind, or she outright lied. Because